right, hello and welcome, and thank you so much for being here. I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And today I want to talk about a new, hot off the press, United States Supreme Court decision in immigration law, and it's the case of Niz Chavez versus Garland, all right? And this was decided, it was decided on April 29th of 2021. It was just last week. I'm filming this, it's the 3rd of May, so it's less than a week old, all right? And so it's a cool case, all right? And this case says, and to give some background and to give some context, it's talking about E42B cancellation of removal cases, and it's talking about, okay, when does a notice to appear, which is your NTA, which is the charging document in immigration court, when does a notice to appear stop time, stop the calculation of the 10 years for the purpose of cancellation of removal? Because remember, you've got to show 10 years of continuous physical presence before the issuance of a valid notice to appear. And what I'm emphasizing there is the word valid. All right, like what is a valid notice to appear? And remember, we've had some movement in this area in the past several years, all right? The case Pereira versus Sessions originally said that if there's some information missing, it does not trigger the stop time rule. If there's some information, key information missing on the notice to appear, it does not trigger the stop time rule. And here what they're saying, and what the BIA had originally said is, well, but if you've got a notice to appear that's deficient, but then you supplement it with a hearing notice that has the location and the time of the hearing, then the two of those things working together should stop time. And what the United States Supreme Court is saying is, nuh-uh, nope, that's not true. That's not the way it works, government. And so what I want to do today is I want to share with you, and I'm going to read for you the syllabus, like the synopsis of the case. And this is the summary that's written in the, they call it the syllabus, that's written by the U.S. Supreme Court before getting into the full opinion. All right, so I'm going to share my screen and we'll go step by step through this, and I'm going to talk about notices to appear and the potential implications of this case. All right, so here we are, Supreme Court of the United States, Niz Chavez versus Garland, Garland being the Attorney General of the United States, argued November 9th of last year, decided April 29th. All right, here we go. I'm going to read. I'll make my talking head here a little bit larger just so you can see me. Hello. And here we go. All right. Non-permanent resident aliens ordered removed from the United States under federal immigration law may be eligible for discretionary relief if, among other things, they can establish continuous presence in the country for at least 10 years. 10 years, continuous physical presence requirement for cancellation of removal. But the so-called stop time rule included in IRA, the Illegal Immigration Reform and Immigrant Responsibility Act, which was passed in 1996, provides that the period of continuous residence shall be deemed to end when the immigrant, when the alien, is served a quote-unquote notice to appear, all right, in removal proceedings under Section 1229A and Section 1229BD1, all right? The term notice to appear is defined as quote-unquote written notice specifying and then certain information, such as the charges against the alien, the time and place at which the removal proceedings will be held, etc. And there they're quoting the Immigration Nationality Act. And I will talk about Section 239 of the Immigration Nationality Act, which details everything that by law your notice to appear is supposed to include. All right. And then it talks about any notice that omits any of the statutorily required information does not trigger the stop time rule. And that was decided in Pereira versus Sessions just a couple years ago. Okay, under the Trump administration, Jeff Sessions as the Attorney General, that was the Pereira case. Here, the government ordered the removal of a petitioner, Augusto Niz Chavez, and sent him a document containing the charges against him. 2 months later, it sent a second document providing Mr. Niz Chavez with the time and place of his hearing, the quote-unquote hearing notice, all right? The government contends that because of those two documents, all right, two documents, one, the notice to appear, and two, that hearing notice, the government's arguing in this case that because there were two documents that collectively specified all of this stuff for a notice to appear, that the person's continuous presence stopped when he was served with that second document. And the US Supreme Court says, nope, that's wrong. That's not the way the law is written, all right? And so here's the holding, all right? A notice to appear sufficient to trigger IRA's stop time rule is a single document immigration government. It's a single document. You can't have it be two documents or three or 5 or 20. It's got to be one single document. And it's got to contain all the information about an individual's removal hearing as specified in this section of the law. Okay? Section 1229BD1 states that the stop time rule is triggered by the servicing of a notice. And this Section 1229A1 explains that written notice is referred to as the notice to appear. And Congress's decision to use the indefinite article A suggested it is envisioned that a single notice provided at a discrete time rather than a series of notices that collectively provide that required information. While the indefinite article A can sometimes be read to permit multiple installments, such as a manuscript delivered over months, that's not true for words like notice that can refer to either a countable object, like a notice, or a non-countable abstraction, like sufficient notice, all right? The inclusion of an indefinite article suggests Congress used notice in its countable sense. How about this, all right? More broadly, Congress has used indefinite articles to describe other case-initiating pleadings, such as an indictment, an information, or a civil complaint. And they're talking about federal rules of criminal procedure, federal rules of civil procedure, right? So they're comparing immigration court documents with the way it works in the rest of the world, okay? And none suggest that these documents might be delivered by installment. Get it? So nor does the Dictionary Act aid the government, as that provision merely tells readers that the U.S. Code, readers of the U.S. Code to assume, quote, words importing the singular include and apply to several persons, parties, or things. That doesn't help much. Blah, 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 blah. While it certainly allows the government to send multiple notices to appear to multiple people, it does not mean a notice to appear can consist of multiple documents. Okay? B, and hopefully I'm not going too fast, right? We're making our way through it, all right? B, the IRA's structure and history support requiring the government to issue a single notice continuing all the required information. All right, I'm not going to read word for word this section. C, the government claims that not knowing the hearing officer's availability when it initiates removal proceedings makes it difficult to produce compliant notices. It also claims that it makes little sense to require time and place information in a notice to appear when that information may be later changed. Besides, the government stresses its own administrative regulations has always authorized its current practice. But on the government's account, it would be free to send a person who is not from this country, someone who may be unfamiliar with English and the habits of American bureaucracies, a series of letters over the course of weeks, months, maybe years, each containing a new morsel of vital information. Congress could reasonably have wished to foreclose that possibility, and ultimately, pleas of administrative inconvenience never, quote unquote, justify departing from the statute's clear text. The modest threshold Congress provided to invoke the stop time rule is clear from the text and must be complied with here. All right, so they reversed the Sixth Circuit that had decided differently. There is a dissenting opinion. Okay, I am going to read the first three sentences of Justice Gorsuch's decision here because I love it. I just love it. I think it's worth reading. And then I'm going to talk about, okay, what's really required in a notice to appear. And then we'll talk about what this case really means in your situation for you. Okay, so listen to these just first couple sentences. Anyone who has applied for a passport, filed for Social Security benefits, or sought a license understands the government's affinity for forms. Make a mistake or skip a page, go back and try again, sometimes with a penalty for causing the trouble. But it turns out that the federal government finds some of its own forms frustrating too. All right. The Illegal Immigration Reform and Immigrant Responsibility Act of 1996, otherwise known as IRA, requires the government to serve a quote unquote notice to appear on individuals it wishes to remove from this country. At first blush, a notice to appear might seem to be just that, a single document containing all the information an individual needs to know about his removal hearing. But the government says supplying so much information in a single form is too taxing. It needs more flexibility, allowing its officials to provide information in separate mailings, as many as they wish, over time, as long as they find it convenient. The question for us is whether the law Congress adopted tolerates the government's preferred practice. And that's all I'll read of that. And the answer that the Supreme Court says is no, it does not. So Immigration, Department of Homeland Security, sorry, you've got to go through the extra step and actually create a notice to appear if you wanted to actually stop time against our clients to prevent them from being eligible for cancellation of removal. Got it? And so let's look at it in a little bit more specifics, all right? What is required on a notice to appear? So here is, this is my own language here, but I'm pulling it straight from the code, all right? So if you look at section 239A1 of the Immigration Nationality Act, it lists, Congress lists what needs to be included in the notice to appear. And so that list says it's got to show the nature of the proceedings, like what we're doing, deportation proceedings, all right, removal proceedings, quote unquote. It's got to show the legal authority for the proceedings. What section of the law are we bringing these proceedings under? It's got to describe factual allegations showing a violation of immigration law. It's got to show the legal charges. So you're charged with being removable under what section, okay, against the respondent or against the person. 5, the respondent, it's got to show that the respondent has the right to be represented by counsel. It's got to show that the respondent must immediately provide address and phone number, okay? It's got to show that failure to update contact information can be held against the client. It's got to show the place and time of the proceedings. We could highlight that because that's what this case is about. And it's got to show that the respondent will be ordered removed in absentia if he fails to appear. That's what the notice to appear needs to include by statute, okay? And so if you have questions about that, check it out, 239A1, that's where it is, okay? And so that is what the US Supreme Court is saying must exist in order for this notice to appear to quote unquote stop time. So I'm going to stop sharing my screen and I'm going to talk with you about the implications of this decision. Like, what does it mean for you? All right. So the first big question is, are you applying for cancellation of removal? All right. If you're in immigration court, if you are applying for cancellation of removal, the question is, did you have 10 years of continuous physical presence here in the United States before you were issued a notice to appear? Because if you did, hey, great, no problem. If you didn't, pull out that notice. and see, did it really comply with all of these things? Because if it didn't comply with all of these things, what the US Supreme Court is saying is, hey, maybe you're eligible. Maybe you didn't have time stopped against you. Maybe you can keep showing your 10 years of continuous physical presence in the US. Got it? Okay. So that's the simple way that this case will or could affect you. Okay? If you're in immigration proceedings and if you are filing for cancellation of removal. Now, what is a potential broader implication of this case? If you're in immigration proceedings, the way that the government puts a person in immigration proceedings is through the quote-unquote notice to appear. Got it? The way that the government puts a person on notice that they are now going to immigration court is through this document that's called a notice to appear. That's the purpose of the notice to appear. And what the Supreme Court is saying is, at least in this cancellation of removal context, having multiple notices doesn't do the trick. Okay? And so they did not say that having multiple notices doesn't even work to start removal proceedings against a person, but there might be room to make that argument, right? If the Supreme Court is saying, hey, if you're missing that key piece of information, it's not a valid notice for cancellation of removal cases, isn't it possible that we could argue that that same notice that didn't include all that information, the way the government loves to not include all of its information, couldn't we argue that that didn't even satisfy, it didn't even suffice to put our client in removal proceedings from the beginning? And if we could argue that, heck, maybe we could file what's called a motion to terminate. Maybe we could ask an immigration judge to dismiss the case completely. Maybe we could get the case thrown out because your notice to appear was not valid, which means that the court, the immigration court, theoretically doesn't even have jurisdiction over your case. Now, here's the thing. You could try, in my opinion, you could try to put forward that argument. And in my opinion, there are immigration lawyers that are reading this decision, just like I am, and our minds are going, okay, we could file a motion to terminate here. We could get rid of your case completely here. But here's what I want to be clear about. And so pay attention if you're thinking about doing that. It's possible, so we saw this with the Pereira case. It's possible that you file that motion to terminate. Heck, it's even possible that your immigration judge approves that motion to terminate. But if they approve it and then your case gets terminated, the chances would be likely that the government, that the DHS, the Department of Homeland Security, would appeal your termination to the Board of Immigration Appeals. All right? And it's possible that in front of the BIA, they would say, hey, wait a second, that's actually not what the Supreme Court said in this case. The Supreme Court was just talking about the stop time rule for cancellation of removal cases. They didn't take it to that next level to say specifically that now any NTA is not valid. All right, any NTA that doesn't comply with everything is not valid for any purpose. All right, they didn't go that far. And so whether or not the BIA, the Board of Immigration Appeals, is willing to go that far is a question. And you could try it. You could try to file that motion to terminate and see what happens, but just be aware there's probably going to be some appeals. There's probably going to be some arguments on both sides of the situation because it's not super clear. Okay? So I hope that this was helpful. It is a cool case. It's especially cool if you're in immigration court and you want to file for cancellation of removal. The first thing to do is to go look at your notice to appear. Did it have all of that required information or didn't it? And if it didn't have, for example, the hearing date, the hearing location, the hearing time, then it didn't stop the clock. It didn't stop your 10 years of continuous physical presence. And so the longer your immigration case persists, the more likely you could become of being eligible for cancellation of removal. That's all I got to say. I know this was a long video. Thank you so much for being with me here today. I'm Otis Landerholm, Landerholm Immigration A.P.C, where we fight for your American dream. And if you have any questions about any of this or about your strategy in immigration court, hey, give us a call. We're just a phone call away. We'd love to help you. All right, thanks a lot. Bye-bye.